So we've been talking about cases and case law, and I want to talk a little bit about statutes and statutory interpretation. The things we've been doing this first week in litigation basics involve common law cases. Cases in which judges are deciding without the existence of a statute passed by the legislature. Cases in which judges are making the law. In your other first semester first year classes, particularly torts and contracts that you'll be having, those are also largely common law subjects, meaning you'll be reading cases in which judges are making law, in which there are no statutes ordinarily passed by the legislature. That's a bit of a distortion of what the situation is generally in the law, because in most areas these days, statutes predominate, not common law. So we want to talk a little bit about statutes, just so you have some idea of statutes and the differences between statutes and common law. Before I get into that, I want to just mention another course that you're going to be having this semester, certainly those of you who are day students, and that is criminal law. And I mention that because criminal law is an interesting mix of common law and statutes. Criminal law developed through the common law, but in all states in this country, criminal law has now been codified by the legislature. So it's kind of a mix, and you'll see that in your classes. So what are the differences between common law, judge-made law, and statutory law? First off, of course, the lawmaking body is different. With statutes, the law is created by democratically elected legislatures and then signed by a democratically elected governor or president. Common law, judge-made law, although it's supposed to reflect society's interests, doesn't have the same direct public input. The input in common law cases comes from individual parties speaking through their lawyers. Courts are, by and large in this country, appointed, not elected. So that's one huge difference. Another difference between common law and statutes is the way the law develops, the movement of the law, if you will. Common law develops incrementally. Particular decisions are put together, synthesized, to develop general principles and rules. The movement of the law is from particular to general. Statutes are different. With a statute, the legislature develops and enacts a general rule at the outset. And then that general rule, the statute, is applied by courts in particular cases. So the movement is not particular to general, as it is with common law, but general first, and then being applied to particular cases second. So there's a different movement. Another important thing to think about with respect to statutes is, of course, the role of the court is different. The court's not the lawmaker, the legislature is. The court's job when it's dealing with a statute, when it's deciding a case in which there's a statute involved, the court's job is to merely implement the law that was created by the legislature. Courts may not like this, but often they are referred to as merely being the agents of the legislature carrying out the legislative will. Courts aren't supposed to change the law. They're not supposed to make the law. They simply apply the law that the legislature created. But of course, statutes are often ambiguous, either generally or as applied to particular situations. And it's the court's role not to change the statute, not to decide what it thinks the law should be, but to interpret the statute, figure out the meaning of the words, and then figure out how those words apply in particular situations. So let's talk for a little bit about statutory interpretation. First, there are different views of what are appropriate statutory interpretation approaches. And this is a very lively debate between judges in this country. The traditional view, or what we might call the traditional view, says the court should look everywhere to help it interpret the statute, including what's called legislative history materials, materials generated during the statutory enactment process. And these legislative history materials, this information that develops in the enactment process, a traditional interpretation approach would say, these are available to a judge in figuring out what the legislature had in mind and what it meant by the words it enacted. Textualists, on the other hand, and there are some very prominent textualists in this country. Justice Scalia, for example, is one of the leading textualists. And a textualist view is it's the text that determines, nothing else. Legislative history materials almost never considered. The other thing that I want to mention just very briefly is the techniques of statutory interpretation. One of the things that you will need to learn, and you will, is how to interpret a statute. And there are a number of techniques that go into interpreting a statute, and I'm not going to go into them all now, but I just want to suggest to you something about statutory interpretation techniques. A statute is a writing. It's text, it's words. We interpret statutes really the same way we interpret any writings: contracts, leases, wills, books. If you're reading a book and you have difficulty figuring out the author's meaning or a poem or whatever, you do interpretation. You figure that out. And that process is similar to the statutory interpretation process. You ask yourself questions. What do the words seem to mean on their face? What's the context suggest about the meaning of the words? What did the author, in the case of a statute, the legislature, have in mind? What was their intent? What was their purpose? Why did they create this writing? What problem were they trying to solve? Might help you understand the meaning. What did people say about this? What was going on at the time that might shed light on the meaning? So statutory interpretation, and again, we're not going to get into it in a lot of detail today, is not something that you don't already know about. You've done it. You've already dealt with interpretation, and the process is very similar.